Good evening, everyone, and welcome to this, the fourth and last in this year's series of Readers' Lectures. I'm very pleased and proud to be able to welcome on your behalf our speaker this evening, Professor Sir Ross Cranston. Ross did his first degree in Australia, second degree at Harvard, DPhil at Oxford, went into academia. I came across him first when he was the Sir John Lubbock Professor of Banking Law, and I had the privilege of being his pupil supervisor when he was starting at the bar, which was interesting for that. From the Centre for Commercial Law Studies at Queen Mary, he went to be Castle Professor at the LSE, but decided that he fancied a challenge. So stood unsuccessfully, unfortunately, against William Hague in Richmond in Yorkshire, before eventually persuading the electors of Dudley by an overwhelming majority to elect him as their Member of Parliament and becoming Her Majesty's Solicitor General in Tony Blair's first administration. Deciding not to stand in the 2005 election, I think it was, Ross then briefly went back to academia before going on the High Court bench as a judge in the Commercial Court and becoming, while he was there, a judge in charge of the Administrative Court. He served for 9 years as a High Court judge. Retiring from that, he's gone back to academia. Talking of books, as some of you may know, I'm a finance lawyer, and I derive great assistance from Ross's book on principles of banking law, which is wonderful. And also, for those of you who are interested in legal history, in 2021 you brought out a book called Making Commercial Law Through Practice, 1830 to 1970, which also is utterly fascinating. I'm sure we're going to get a wonderful talk this evening. Ross, over to you.
Well, Master Reader, Richard, thank you very much. We go back a long way. I'm very indebted to you for your support over the years. In your own distinguished career, you have become a leading commercial lawyer. You have sit on the commercial court, and also you've got an academic bent, and you teach at Oxford and write as well. When you invited me to give this lecture, you asked me to say something about English commercial law and what we can learn about it from its history, building to an extent on the book that you've just mentioned. And what follows is my attempt to fulfill your kind invitation. So let me begin with some history, and then I'll say a little bit about people, and finally I'll move on to what I rather misleadingly call, as you'll discover, practical judging. Now, I'll do this by using as a staging post for some thoughts about this huge topic, actually, a member of this inn, one of England's great commercial judges, and also one who had an academic bent, like you, Richard, Robert Alderson Wright. Lord Wright was called here in June 1900. He became a bencher in 1923 and was made treasurer in 1946. He didn't have early success at the bar. He lectured for over a decade, and I think about 15 years actually, at the LSE in the evening. His teaching is recalled in the dedication to Holdsworth's 12th volume of A History of English Law. Indeed, at one point, Wright considered becoming an academic lawyer. But he stuck with the bar, and his practice eventually took off during the First World War when others went into the services. As I explain later on, he was too old. He took silk in 1917, was appointed to the High Court in 1925, and he went straight to the House of Lords in 1932, and he then retired as a law lord in 1947, having been Master of Rolls for a couple of years along the way. Now, in one of the penetrating intellectual histories of judges and other leading lawyers, my colleague at the LSE, Professor Neil Duxbury, characterizes Wright as an innovative traditionalist. And Neil demonstrates that Wright was effective as a judge in subtly developing the law without undermining established precedent and statutory authority. He describes how Wright applied his belief that the development of the law was necessary because rules sometimes produce absurd and irrational consequences if they're rigidly applied. Now, on that slide, you can see an extract from his speech in a bill of lading case, actually, Northumbrian Shipping Company and Tim. And you can see on the side that he said that commercial law has always been ready, so far as possible, to sacrifice pedantic logical consistency in favour of the convenience in the conduct of business. And as a matter of what I'd call legal policy, there have been various ways historically that this was done. In other words, English judges seeking to accommodate the law to commercial life. Now, let me cover just a few examples of this in the time available. The first is the employment of commercial custom, trade usage, as it's called, used in two ways: to interpret contracts and also to supplement their language by implying terms. During the 19th century, the courts began to take a flexible approach to commercial custom, albeit that to have normative force, custom still had to be proved as a matter of fact. The judges use custom in a variety of contexts. There's a volume of cases where judges recognize the customs of ports, trades, and markets. Hire and deferred purchase agreements, the foundation stones of modern asset finance, were first developed. It was first developed actually in the commercial, not the consumer context, but it was given a boost by decisions which recognized that hiring furniture, for example, was usage in the hotel trade. With high finance, we have this very famous case, Goodwin and Roberts, when in 1875 the House of Lords extended negotiability to the two international bonds, in that case Russian and Hungarian bonds, which were then flooding the market and were finding their way into the investment portfolios of the upper middle classes. And there are other examples as well. In 1940, to revert to Lord Wright, there was a case involving the sale of American wheat, and he and the other law lords agreed with him that the arbitrators could have cured. It was a case about the ambiguity in a standard form contract, and he said that the problem could have been solved by the arbitrators, quote, importing the custom and practice of the trade. By the 1950s, however, commercial custom had faded as a means of transposing commercial practices into law. Partly that was attributable to the greater formalism in legal reasoning which had taken hold and the hardening of the prerequisites to establish commercial custom. Partly it was the spread of standard form contracts so that there was no longer the same need or latitude to imply terms. And partly to imperial decline and the loss of markets, ports and trades, which engendered clear commercial customs. So that by the time Lord Devlin gave a lecture at the LSE in 1951, he could say that a successful claim of custom was extremely rare. And quoting him, it can no longer be regarded as a revivifying source of commercial law. And certainly that was the prevailing view, and was given force when, as you mentioned, Richard, in my early days at 3BB, I was on the margins of the first big case in the Euro markets, Libyan Arab Foreign Bank and Bankers Trust. And Miss Justice Staunton, another inner member, and possibly the one with the longest name, Christopher Stephen Thomas Jonathan Thayer Staunton. He held that no term could be implied in the London deposit contract by commercial custom, that the bank was obliged to repay the Libyans $300 million through the New York clearing system. There are other ways to repay, including in cash. However, unrealistically that was, and that of course meant that because you didn't have to go through New York, you could avoid the President Reagan's freeze on Libyan assets. So commercial custom, that's the first example. Let me take a doctrinal example, where the judges played a facilitative role historically. And the example I take is from sales. In the early 19th century, the judges recognized that there needed to be implied terms in contracts of sale, terms which became a cardinal feature of our law and also our language. Goods have to be fit for the purpose. How often do you hear that these days? And merchantable. The latter was expressed graphically by Lord Ellenborough in his famous dictum, "The purchaser cannot be supposed to buy goods to lay them on a dunghill." These implied terms and their associated remedies were codified at the end of the century by Mackenzie Chalmers in the Sale of Goods Act of 1893. The judges held that the Act and sales law had a wide reach. There's a decision of Lord Wright in 1934 in Camel Laird and Manganese Bronze to that effect, contrary to what the Supreme Court said, or at least in 2016. In codifying these and other rules, Chalmers' stated aim was to, quote, further certainty and definitiveness and to facilitate commerce. But the key point is this. Chalmers saw the rules in the Sale of Goods Act as default rules. They were only to be applied when the parties had not formed an intention or had failed to express it. There you have a view of his notion of what he was doing. But following the common law, Section 55 of the Act allowed the parties to opt out of implied terms about quality which were contained in the Act. And this freedom to contract out of statutory and doctrinal law regimes has been a further and the third vital feature of English commercial law. As a result of party autonomy, historically commercial parties have been able to engage in private lawmaking to design in a largely unfettered manner the arrangements they've desired for their individual transactions, their dealings, and the rules for their markets, institutions, and dispute resolution. And so there were standard form contracts for markets, for shipping, for insurance, and so on. There were institutional rules for places like the Baltic Exchange, which was the home for chartering and the buying and selling of ships. And until the mid-20th century, it was also a centre for international grain trading. There were rules which the commercial parties drew up for the London Clearing House, which still exists and still provides clearing services for international trades, these days in derivatives and swaps and foreign exchange products and so on. And party autonomy happens specifically in sales, which I've mentioned. So the parties to the sale of heavy industrial goods like plant and machinery didn't leave quality issues to the open textured standards of the common law or the 1893 Act, fitness of purpose and merchantability. They actually spelled out in their contracts what they wanted. The contract might require as a precondition that plant and machinery be given the opportunity to perform to the satisfaction of the buyer. The contract might go further with specifications of what was to be manufactured and how, often detailed, and possibly coupled with drawings of its design. And the buyer might even demand a right to inspect and approve the manufacturing process. And the same happened with international commodity sales. The quality standards implied by law were excluded and were laid down instead by the various trade associations in their standard samples and their standard form contracts. So, for example, there's a decision of Mr. Justice Wright, as he was in 1929, that the clause in contract number 30 of the London Corn Trade Association, now GAFTA, was effective in limiting the extent of the seller's liability for the quality of the grain provided. The same happened with remedies. So those international commodity contracts wrote out rejection. It wasn't practical, since it would mean that a seller would have to arrange for what was said by the buyer to be a defective cargo to be disposed of abroad. The other side of freedom of contract was sanctity of contract. As Wright put it on one occasion, only to be overridden by the strongest possible counterbalancing circumstances. Sanctity of contract meant that just because the turn of events bore heavily on a party or circumstances significantly changed to a party's detriment, there was no justification for curial intervention. Now, one can't pretend that there weren't wrinkles in this general picture of the judges facilitating commercial practice through custom, doctrine, and freedom of contract. One wrinkle was the occasional decision made in the face of essential commercial practice. And the example I've got here is an example on the Liverpool cotton market. That was a huge market, of course, Liverpool being a large port and a market. Also an important, as I set out in the book, an important market for wheat futures in the 1930s. And Keynes invested on that wheat futures market and regarded that as the best commodities futures market to invest in. But in this case, it involved the doctrine of undisclosed principle. For the students who may not have come across this yet, that meant that an agent with actual authority and intending to do so could bring his or her principal into contract. Of course, these are all hises in those days. His principal into contractual relations with a third party, even though the fact of the agency was unknown. Now, the judges justified undisclosed principle on the basis of commercial principle, but query whether that was the case. And certainly the doctrine was quite unsuited to markets like the Liverpool cotton market, because brokers wanted to deal with the person in front of them. They didn't want all of a sudden principals to be jumping up and claiming to be the principal and to be the contracting party with the broker, and especially when they chose the good trades and didn't claim the bad trades. Anyhow, those arguments were put through evidence from brokers at first instance, and then it was before the House of Lords, but the House of Lords was unsympathetic. You see what one Lord said there rather emphatically: we're not going to alter the law to suit the views or convenience of the market. But freedom of contract came to the rescue, and you'll see there an extract from a Liverpool cotton broker who was giving evidence to a parliamentary committee when he told the story. There was this case. I took it to the association. I told them that no one was going to be trading if the undisclosed principle rule applied. And so we drew up a new contract whereby dealings were between the parties, and you couldn't have others interfering or claiming on the contract. And there are other examples. There's an example involving Lord Wright, where he acknowledged, it was when he was at first instance, he acknowledged it was about a notice of appropriation having to be given. And he said that meant it actually had to be, he held it was actually had to be given. And it wasn't practical because it had to go, it was a string contract with a commodity sale, and it would take time for the notice to actually reach down through the string. Well, anyhow, what happened was that that ruling was upheld by the Court of Appeal, but what the association did was simply change their contract to address the problem. In addition to what I call the wrinkles, there are at least two glosses on the theme that the judges were always facilitative of commercial dealings. First of all, some of even the most commercially minded judges sometimes exhibited a disconnect with commercial practice. Lord Wright provides an example. In 1936, he gave a lecture at the Holdsworth Club at the University of Birmingham, and he commented that there had grown up around standard form contracts a great mass of detailed and complex rules, and that was certainly the case with bills of lading, insurance contracts, commodity contracts, and so on. But he said, but even with them, we, the courts, fill in the details. In the book, which Richard mentioned at the outset, I hope to have demonstrated that the story is much more complex. It wasn't the court simply filling in the gaps. The reality is a more nuanced story of the contracts being drawn and redrawn by commercial parties with judges and lawyers in the background. A second qualification is that judges were not necessarily in the vanguard in making new law. When they did, it was often after a commercial practice had been developed by commercial parties, or after an innovative legal technique had been contrived by the profession, and these had become entrenched. And what the judges were doing, and it was a valuable, we can't underestimate the value of what they were doing, but what they were doing was giving their imprimatur to those practices and techniques. And so in the great test case of Helby and Matthews in hire purchase was there, it had been around for some time, they gave their approval. And there are other examples where they gave approval to particular techniques, bank overdrafts, documentary credits, very important. They glossed over the problem of consideration which arises in the context of documentary credits. With the Gaming Acts, they read that legislation down so as not to disrupt futures dealings, which had grown up as an important aspect of the markets. To quote someone, Richard and I know very well Roy Good. And I think Sir Roy is a member here, is he not?
Yes, he is indeed.
Anyhow, Sir Roy, in his colourful phrase, said, quote, he said there was the power of the market to pull itself up by its own legal bootstraps, and the pressure on courts to avoid decisions that would threaten the orderly continuance of the market. So to sum up this part of the talk, and here's the advertising for the book, commercial law furnished a broad framework in which commercial and financial activity flourished. Judging was animated by broad principles, generally facilitative of commercial activity. Party autonomy empowered commercial parties to design the market rules, standard form contracts, and institutions they fancied. And freedom of contract enabled commercial parties to have disputes dealt with, as something I haven't mentioned, dealt with through private dispute settlement in the form of arbitration. And of course it allowed, as I said before, it allowed commercial parties to remedy the occasional court ruling with which they found uncomfortable. So let me turn to my second topic, and it's about people, specifically to some of the leading commercial judges who set the tone. Although in focusing on the judges, I don't underestimate the importance of the legal profession in forging our commercial law, albeit historically, as I try to show in the book, that it's a mixed picture. For present purposes, my key point is this: the important role of specialist judges in the success of English commercial law. Not generalist judges, and certainly not career judges in the civil law tradition. In other words, judges who work their way up through a state civil service system. So let's consider some examples. Lord Wright. Little is known of his background and early schooling and early adulthood until he went to Trinity College, Cambridge, at the mature age of 24. All he entered in Who's Who was that he was, quote, privately educated. However, we do know that his father was a Marine superintendent on Tyneside. In his D&B entry, the late Dr. Robert Stevens opines that it was almost certain that Wright had absorbed a great sense of commercial practice from his father, and in his early years of work, and possibly had been employed with his father. So that connection to commerce features with other judges making notable contributions to commercial law. Colin Blackburn's father was a Glasgow merchant. He owned sugar plantations, and of course that meant he had enslaved people in Jamaica, as it happened, and as a corollary, the father received a substantial compensation after emancipation. But following Blackburn's book on sale in 1845, he built up a very big practice in heavy mercantile cases. Lord Bramwell, his father was a banker, and Bramwell served an apprenticeship as a clerk in the bank. I'm indebted to the portraits of commercial court judges that appear on the private commercial court website, which I understand is a very fine work of Nigel Eaton, King's Counsel. These portraits evidence that a considerable number of those judges in the early judges in the commercial court were from had commerce in their family. Pickford, of course, from the family of carriers. Walton, from a prosperous family of Liverpool merchants. As to later judges, there were merchants in Lord Roche's mother's side. Frank Mackinnon, Lord Justice Mackinnon, he was the son of a Lloyd's underwriter. Alan McHatter's family were bullion brokers, so it goes on. And then, of course, we've got Lord Justice Scrutton, T.E. Scrutton, a very big figure in commercial law, with his family history in shipping, shipbroking, insurance broking, marine salvage, surveying, and later stevedoring. And as with others, Scrutton was an author of books on the subject, books on mercantile law, the Merchant Shipping Act, and still with us in its 25th edition, his book on charter parties and bills of lading. Now, he appeared regularly in commercial cases against another of your great commercial judges, controversial figure, J.A. Hamilton, Lord Sumner, the son of a merchant son of a Manchester iron merchant. The last political law lord, as one of his biographers describes him. But even without this vicarious knowledge of commerce through family background, English commercial judges learnt their trade in commercial chambers. So Lord Wright was, along with Lord Atkin and with Frank Mackinnon, a pupil of Scrutton. And Scrutton had an enormous practice in shipping and insurance, as well as banking and sales. And later they themselves acquired large commercial practices, and they had pupils, and so that tradition continues today. So English commercial litigation, certainly after the foundation of the commercial court, was heard by judges and argued by counsel familiar with the ethos of commerce and its practices, in addition to their knowledge of the substantive commercial law and procedure. And no doubt they brought that knowledge and sentiment to bear in their judging. Now, in his outstanding biography of Scrutton, Sir David Foxton, draws on the concept of situation sense from an American jurist, the main author of the US Uniform Commercial Code, Professor Carl Llewellyn. And as David Foxton sets out, Scrutton's situation sense was not lightly worn and was frequently expressed to justify his conclusions. And so he paraded his knowledge of the China trade, timber dealings, coal storage business, and so on. And you'll see this in the reported cases. He actually mentions this as anyone knows who knows anything about the China trade, etc. That didn't mean he always approved of commercial practices. There are several decisions after when he refused to endorse it. For example, there's one case where a practice had grown up of presenting a cover note rather than a policy of insurance under a CIF contract, and there are other examples as well. In the case law, there are examples of other judges adopting commercial practice as a template for reasoning, albeit that it fell short of trade usage. As well, a commercial practice or commercial opinion was used as a prop for some judges when some judges were reading a contract or a statute, or as an added justification for the conclusions reached through more conventional avenues. And there are various cases, for example, where the judges drew on what they characterized as, quote, City of London opinion to buttress their legal conclusions. Now, this notion of situation sense, which Llewellyn developed and which David Foxton adopts, can't be pressed too far. One reason is that even the most outstanding commercial judges can't know every conceivable part of the commercial world, and these days specialization sets in fairly early in practice. An example that I found when I was going through the archives of the PLA involves Scrutton himself. He appeared for shipping interest before a royal commission, which led to the establishment of the Port of London Authority in 1909. And he was cross-examining the chair of the chairman of the London and India Docks Company, CJC Scott. And Scrutton inquired about this North American clause. And Scott says to him, well, this is never used here. Anyhow, there's back and forth, and Scott says, well, if you don't believe me, I paraphrase, go and ask P&O. They'll tell you that it's not used. Anyhow, Scrutton didn't accept the answer, and he pointed to the contract. There's the contract. And then I think I've got, it's never, the explanation Scott gave is never used here. And it's entirely inoperative. And he gave an explanation about why it wasn't used, because when the when the cargo comes across the ship's tackle, it's still being dealt with by the vessel. So, other than situation sense, which I've mentioned, how else might we explain the non-legal factors bearing on commercial judging? As I said, David Foxton used this notion of situation sense. After a long experience in the commercial world, commercial law, you get a notion of what works. But let me canvass a few other possibilities, in some cases, if only to exclude them. First, there's the enormous US literature, not only on the US Supreme Court, but also on the lower courts, such as the federal courts of appeals, where they introduce the notion of a judge's, quote, attitudes or, quote, ideological preferences, and that their legal reasoning is a rationalization of these factors. Now, these studies involve detailed and intricate statistical analysis. They're often not done by lawyers, they're done by political scientists. But here's a recent example of this being used in this sort of type of analysis being used here by Professor Carl O'Callaghan, where she looked at the UK Supreme Court and values. And she identified those values by a content analysis. In other words, she had a database, I think, of over 600 judgments, and she went through them, and she tried to categorize the values that underlay the decisions. And then she then categorized them in a very, what I find rather peculiar way. She used the work of a social psychologist, Shalom Schwartz. But the most important values she identified were tradition and conformity, self-direction, which includes things like liberty and autonomy and so on, and universalism. Achievement was there as a value, but less important. But there's nothing like commercial situation sense. And, of course, that reflects the Supreme Court's caseload. Relatively few commercial cases these days compared with the huge volume of public law, human rights, and private law litigation. So some of this analysis isn't applicable, although query, what would be produced if you did Professor Cahill O'Callaghan's analysis on the commercial court itself. But we can't dismiss that completely out of hand too readily in terms of the influence of attitudes and values. In a lecture to the Cambridge University Law Society in 1920, Scruton remarked that it was rather difficult to attain impartiality in any system. Not conscious impartiality, I'm quoting, the habits you are trained in, the people with whom you mix, lead to your having a certain class of ideas of such nature that when you have to deal with other ideas, you don't give as sound and accurate a judgment as you would wish. It's very difficult sometimes to be sure that you will put yourself into a thoroughly impartial position between two disputants, one of your own class and not one of your own class. A very insightful comment. Now, Scruton made those remarks in the context of one of the great issues of the day in the early 1920s, the rise of the labour movement, the role of the trade unions. And he went on to say that that sort of problem didn't arise in the context of commercial cases. And to an extent, that's understandable. Ideological preferences or values favouring, he was talking about whether the court was favouring employers over employees. or in the present day human rights claimants over the state. That certainly has more resonance than, say, favouring charterers over owners. But I think with commercial disputes away from the commercial court, in areas where the parties are not in an equal bargaining position, attitudes, values, and other non-legal factors might have greater purchase, even if, as Scruton put it, unconsciously. For all its great virtues, English commercial law, forged in the context of the type of dispute reaching the commercial court, is not all that suitable, or is unsuitable for other types of dispute. A point which Carl Llewellyn noted in his typical mannered way when he characterized English judges colouring with blue water, I quote, colouring with blue water, in other words, he's talking about international sales, all contracts for wares. That's why for consumer transactions, a separate legislative code has been necessary. Let me just quickly give a historical example. Hire purchase, and I'm talking about non-commercial hire purchase here, by the 1930s had become quite important for household goods, increasingly for motor vehicles. Abuses were in consumer hire purchase were legion. They were set out in this report, and there's a few extracts there, prepared by Ellen Wilkinson, MP, who introduced the first regulation of hire purchase in the Hire Purchase Act of 1938. It was a private member's bill, and she had all party support for that. And so there were problems with minimum payment clauses and snatchbacks and so on, which we don't have time to go into. But the point is this: for many years, and there were a few cases that got to the higher courts, there was a refusal to assist hirers in these cases until Lord Denning arrived with the concept of fundamental breach. But after the First World War, county court judges became quite prominent critics of the practice of financiers and dealers. And indeed, the trade press evidenced that some financiers knew to avoid bringing their cases before certain county court judges because of the hostility they would face. And for present purposes, one can speculate about the role of attitudes and ideological preferences or even emotions in the decision-making of these county court judges. And I mention emotions, and just to anticipate, because the slides are a bit out of order, I've got a reference to this American article, Heart versus Head. Now, these three authors, one of them is a judge, have produced quite a number of articles, and they have, what they do, when they're teaching when they're doing training for judges, they give them questionnaires, and they ask them to fill out the questionnaires. And as a result of that, they've got a huge database, and they analyze that. But anyhow, heart versus head. In some cases, they demonstrate, to their satisfaction anyhow, that some judges, in some cases, are moved by their heart rather than their head. So I've moved into this third subject, what I've described as practical judging. There are, of course, conventional topics like fact-finding, which still give trouble. There was a recent judgment by Mrs. Justice Cockrell in Jaffe and Grable Capital, which advanced our thinking about that, drawing on Sir Andrew Popperwell's lecture last year to Combar. There's precedent. I mentioned at the outset Professor Duxbury's characterization of Lord Wright as an innovative traditionalist, since, as Wright put it on one occasion, precedents can be used to lead advances in the law. Precedent still gives rise to trouble. Lord Leggett recently gave a lecture where he castigated the textual approach to precedent, the rule-based approach to precedent, and said precedent actually involves a much more sophisticated, requires a much more sophisticated analysis. But let me put aside those conventional topics about practical judging and touch on three disparate topics. And the first is the use of general concepts in commercial law reasoning. And the example I'm going to take is certainty. Now, I had to get in someone from my inn, Gray's, and it's Lord Atkin. And there he is on the, we've got the photograph of Gray's. There he is on the Abu Dhabi jetty. He was actually born in Brisbane, about 3 miles from where I was born. A lot earlier, I have to say. But he and his father was very prominent in Queensland politics. But anyhow, that's another story. Atkin, you can see there, I won't read it out, but in summary, he's saying we need certainty in commercial law, even if it causes hardship. And so certainty and the acceptance of it, and its corollary, the strict application of rules, the merits in individual cases taking a back seat, all that is a constant theme. And you can trace it back to what Lord Mansfield said in the 18th century, that certainty was absolutely necessary so that commercial parties would know what the law was. And as Atkin says, this means that sometimes merits get lost. And there are familiar examples in commercial law. The example of the owner who withdraws a vessel because of a minor late payment to take advantage of a rising market on chartering rates, and buyers using immaterial breaches to refuse delivery because they can sell more profitably elsewhere. But despite those with unmeritorious claims profiting at the expense of others, the assumption runs that the bright line rules mean a greater certainty, a greater consistency in the court's decision making that promotes its own fairness. And also there's an argument, what is sauce for the goose is sauce for the gander. You might be done down one day, but you can take advantage of the bright line rule the next day. The assumption is that these bright line rules are readily understood. They can be applied in commercial practice by commercial parties, and that ensures that not only can they plan, but as your Lord Sumner put it on one occasion, they could also, quote, gather their fate then and there. In other words, if something goes wrong, they know who, in most cases, who will benefit. One corollary of certainty is that the notion of good faith has never really taken a firm root in our commercial law. So that's one aspect. A second aspect is common sense. Lord Wright said publicly on one occasion that common sense was a sort of lifeline. That was his phrase. And that sentiment was later echoed by Lord Wilberforce. You can see in private correspondence with the editor of the LQR I don't say that there. It was a memorandum he'd sent to Goodhart, Professor Goodhart. And you can see there that he says that common sense has a much more fundamental role in the law. Now, common sense, what do we mean? Well, we mean what everyone knows. No special expertise is required. It's apparent from the practices of daily life. With judicial decision-making, we might translate it and say it's what everyone knows to be fair and just in the context of a particular case. But, of course, common sense is problematic without elaboration and without critical reflection. Common sense can vary across groups, societies, and time. Another difficulty is that as with all human beings, judges are unconsciously impacted by cognitive limitations, and their notions of common sense are moulded by what the writers call heuristics or biases. So while common sense can be based on sound knowledge, inherited wisdom and experience, it can also be a collection of unsound facts, fixed attitudes and popular prejudices. And the upshot is that common sense of some can be nonsense to others. Common sense may have a surer foothold in specific contexts. One example, going back to Lord Mansfield, is that it is deployed, of course. Business common sense is used in the interpretation of commercial documents. The authorities established, of course, that commercial common sense should not be used to undermine contractual language, nor should it be used to remedy retrospectively what turns out to be a bad bargain in the light of facts. There's also the danger identified by Lord Neuberger that judges should not, quote, overconfidently assume the role of arbiter of commercial reasonableness or likelihood. So that's common sense. It can have a role and does have a role. Thirdly, there's what I would turn I turn to intuition. There's a famous judge and academic, now retired, Richard Posner, and he talks about the resemblance between common sense and intuition. But I think another member of this Lord Sumption, told Alan Patterson, who has written two fantastic books, one 40 years ago on the House of Lords and one on the Supreme Court about 10 years ago, where he interviewed judges, members of the House of Lords and members of the Supreme Court. But anyhow, Jonathan Sumption told Alan Patterson, he said this: "Yes, I do have instinctive feeling. I think everybody does. How hard it is to shift me on it depends entirely on what sort of case it is and how much I know about the subject. How often I am persuaded my initial instinct is just wrong in principle? Well, probably not very often. When it happens, it tends to be in cases in subject areas in which I'm not so familiar as some of my colleagues." Now, there's little I can add to that because it's a brilliant summary of intuition. And the fact is that judges, even commercial judges, rely on intuition in decision-making. They have to. They have to make decisions quickly. In cases, during trials, for example, dealing with matters on papers where there's a pressure to deal with cases. But also, it in a way links back to this notion of situation sense, Llewellyn's situation sense. You just know because you're so familiar with an area. You have an intuition about what is likely to be the best outcome. There are dangers, of course. To quote another member of Gray's Inn, Francis Bacon, he said 400 years ago that once a person's understanding is settled on something, I'm quoting, it draws everything else also to support and agree with it. and if it encounters a larger number of more powerful countervailing examples, it either fails to notice them or disregards them, or makes fine distinctions to dismiss and reject them. Now, in other words, there is what we now call confirmation bias. The judge may adhere to a particular decision reached intuitively, while with a bit more thought or a bit of skepticism, he or she would take a different view. Other potential errors or heuristics. Another one is hindsight bias. Baron Bramwell put it in an early case, nothing is so easy as to be wise after the event. And there are other cognitive biases as well, consequent on using intuition. But notions of common sense, intuition, possibly even attitudes, do have a role in practical judging. So a few high-level conclusions. First, as I've said, English commercial court and commercial judges have generally attempted to facilitate commercial transactions. It was put rather starkly by, again, I think one of your members, Lord Gough, who said that we're here to help and not to help business people and not to hinder them. We're there to give effect to their transactions, not to frustrate them. We are to oil the wheels of commerce and not to put a spanner in the works or even grit in the oil. So there's that aspect. That was the first part of my talk. Secondly, people matter, in particular the expertise of those litigating commercial disputes, judges and the commercial practitioners working together. We can't underestimate that. We can't underestimate the importance of the commercial court and its work. Other judges around the world look to the commercial court. And then thirdly, we need more than conventional tools to understand judging. I quoted Scruton earlier. Here are the remarks I came across in the what are now called the London Archives by John Morris, who was a prominent company lawyer at the end of the 19th century in what became what is now Ashurst. And he tells his story that he appeared not before a commercial judge but before the Vice Chancellor, and he appeared against a charming old solicitor who used every argument to induce me to abandon what he considered to be an absolutely hopeless case. The Vice-Chancellor was persuaded to rule in my favour. I afterwards called upon my solicitor friend, Morris, I see now how you did it. The law was it against you, but you went to the poor man's heart. Well, possibly. Anyhow, in this country, I think more work can be done, and perhaps a book can be written, James, about how these other factors play a role in practical judging. Well, thank you very much.
We have time, I hope, for a few questions. So, has anyone got any questions? Julia? Hold on, take the microphone.
Thank you very much indeed for an absolutely fascinating traverse of commercial law. I wanted to ask you, in recent years, there are certain judgments of Lord Leggett, going back to the time when he was on the High Court bench and through the Court of Appeal, suggesting that he is quite keen on opening up a role for good faith in contractual analysis. which, as you pointed out, is something that English law, certainly commercial law, has hitherto rather set its face against, save in very carefully confined circumstances such as non-disclosure in insurance contracts. And I wondered whether you had a view on that and how likely it was to take root and what the effect would be if it did.
Well, it's a matter of huge debate. I will just tell a story that in one case I tried a case, and the contract said specifically the parties will act in good faith. And so I said, oh, well, some effect should be given to this. And one of the parties I held had not acted in good faith. The case went to the Court of Appeal, and they said, even though the parties said explicitly they should act in good faith, we're going to ignore that. Parties can take advantage of their contractual rights elsewhere in the contract. I have to say I've got no firm views on one way or the other. There's a huge academic literature. I'm not sure that if we had good faith it would go anywhere. It really depends on context, I think. But maybe we can chat about that later on. I should say, I'm quite firm in this division between commercial court law and consumer law. I think there we're dealing with something quite different. And so in that context, I think the notion of fair dealing would be very beneficial, and even if not developed by the judges, should be developed by statute.
Yes, Ross, can I add in a question from online? Can you say anything about your views on commercial contracts with small and medium businesses, in which the balance of power can be very different between parties and can look closer to a consumer contract? Do the courts offer sufficient protection?
Well, it depends on what you mean by SMEs, but some are at one end of the spectrum, and others are more consumer-type transactions. In some jurisdictions of the Commonwealth, the legislation actually aligns the benefits that consumers have, the benefits which SMEs have, with those that consumers have. So, as a matter of policy, they get comparable or the same benefits. But one only has to hear about the way that, for example, farmers might be treated by supermarkets to realize that there is an imbalance, and sometimes not necessarily in the overall public good.
Do we have any more questions? Yes. Wait for the mic.
Yes, thank you for the very fascinating talk. My question is, do you think, functionally speaking, there is if judges know about their own biases, or they actually could this sort of field of study on how judges actually come to their conclusions, do you think it would help the law develop in a sense, or because in the end judges have to come to a conclusion or another, so will they eventually still be trapped in their own so-called common sense or values, or in a sense biases?
I think it's very important that judges acknowledge the basic values, and one of them is impartiality. It's important that one is conscious of any bias that one might have. One is conscious of any emotional reaction that one might have. I think one can have emotions. I mean, I think, James, without quoting you out of school, in one case you had an emotional reaction, as it were, to a particularly traumatic case. And certainly, when I had to sit in the Court of Appeal Criminal Division, some of those cases, some of those appeals were pretty dreadful. But So you did have that emotion, but I think you have to always be conscious of what your biases might be, what your emotional reactions might be. You have, after all, taken a judicial oath. You have to act as impartially as you can.
Any more? Yes.
No, actually, I'm going to go that way.
Hello, Matthew Reeves. Thank you very much for that talk. I had a question as to whether you think there are any new techniques in data collection or analysis which might assist in evaluating potentially the biases of judges, whether AI, for example, might assist in developing new techniques and new standards for impartiality and judicial thinking.
I haven't thought about AI in that context. There's there's quite a literature developing about how AI might be used to actually give decisions in very straightforward cases. Yeah, it's a possibility. I mean, what these sort of, Rachel Callaghan's research involved, it was, a huge amount of data, and some of these American cases, some of these American examples, there's a huge collection of data, very sophisticated statistical techniques. Now, AI might be able to, might enable that much more quickly and efficiently. But they have, there's a data center in the States, which I think covers something like 300,000 decisions of the US, the federal courts of appeals, and that's developed in such a way that they can analyze that sort of thing quite quickly. But AI might help. Yeah, it's a very interesting thought, actually.
One more question from online. Do you think the reliance on instincts and intuitions by judges in commercial cases is or should be greater when dealing with matters of fact or matters of law?
I think when, for example, Jonathan Sonchon's talking about instinct, it's not so much fact, it's when you've got the facts and you've got the law, but you sort of see the case. You may not have everything about the case, but you sort of have an instinctive reaction. I mean, I don't know whether you've had that. I mean, you sit in Chancery as well, I think, don't you? I think sometimes, one does have an instinctive reaction. I mean, Lord Justice Dingerman's, when you're sitting in the Court of Appeal Criminal Division, you've seen that sort of case many, many times, and so you can have a sort of instinctive reaction. The important thing, though, is to, and I see Lord Justice Green as well, you have to be conscious that you might be wrong, and you have to reflect on the instinctive reaction. Oh, this is what I think it is. This is what I think is the answer. You have to reflect, be conscious of what you might be doing. Maybe take a bit longer. I mean, there's all these. There's a great deal of argument about System 1 and System 2 thinking, and System 1 thinking, instinctive thinking, and generally the notion is it's bad. I don't think it is. I think it's instinctive reaction. You just have to get through the work in some cases, and therefore you have to use your instincts. But you should always be conscious that you may be wrong.
I've got a question of my own. You've mentioned a number of inputs into judicial reasoning. One thing you haven't mentioned is academic writing. I mean, I'm just thinking in my own area, for example, the law of intermediated securities, the idea of the chain of trusts and the no look-through principle. The market was doing it. Joanna Benjamin, Professor Benjamin, Roy Good, Professor Good, analysed it in the 1990s, and the market carried on the assumption that that's the way it worked. And we don't really get it analysed until Lehman has gone wrong and Mr. Justice Briggs, as he then was, starts saying, well, this seems right. We don't get it to the Court of Appeal until Secure Capital in 2017. Meanwhile, everybody's worked on the basis of, well, this is the analysis that academics have put forward, and that's market is happy to go on that basis.
Yeah. I had a separate section on academic writing, but you said 45 minutes, I think you said, or 50 minutes, couldn't be longer. So that section went. Academic writing, of course, has been very important. I mean, the whole notion of unjust enrichment, but other areas as well where academic writing has been important. But in terms of your particular point, Richard, that is a constant story, not so much academic writing, but commercial practice. And then eventually, it happened with futures contracts. It wasn't, they developed in the 19th century, late 19th century, and it wasn't until there was a judgment in was it 1916 or 26? I can't remember, but that finally said, yes, that's all right. What the market is doing is all right. So it was this notion of the courts giving an imprimatur to commercial practice, or, as Roy put it, pulling yourself up by the bootstraps.
Absolutely. Any more questions? Yes.
Hi, thanks for a very interesting talk. I'm a complete stranger to commercial law, but the way I tried to understand your talk was regarding common sense principles. I tried to think back to my jurisprudence lessons regarding Ronald Dworkin and how he specified about the Judge Hercules, and how he tries to go through the penumbra of law and try to make the best decision based on his intuition, his common sense, I guess. So my question was really to do with intuition. Is there any sort of example that you can give where intuition has ever contradicted the principle of the convenience of business in legal history?
I can't really. My talk was more focused on what you could generally describe as social science literature rather than jurisprudential literature. And that's, Ronald Dworkin and Hercules, you mentioned, quite important in terms of thinking about it. But with due respect to anyone in the room, there are Hercules around. This is the great figure who can know everything, who can draw everything together and then make the right decision. I don't think that's how it happens. You're working under pressure, you have to decide cases, you have to get through the caseload, even with a very important case where you've got sophisticated arguments. You can't go forever trying to produce the perfect judgment, which that sort of analysis, that jurisprudential analysis suggests. I think it's a bit more down to earth and practical than what some of the jurists say. And that's why Llewellyn, who was a great commercial lawyer, actually, that's why I think, his notion of situation sense is quite important. It's sort of what he was talking about, a sort of instinctive reaction as well. You have, because of your knowledge of commercial law, because of your feel for the subject, yes, that seems to be the right outcome. You'll never be certain. And as I sort of said, you can sometimes go on appeal and be told you got it completely wrong, but you just accept that, or not.
One or two more. Yes.
Hello. So In your talk, you have outlined how sons of people in business have used the law to follow business custom and to oil the cogs of a business machine. I'm wondering if the systems of commercial law can be used by children who are growing up in a climate crisis to give effect to promises made by companies in particular to abide by certain green pledges and other aspects of environmental compliance. So can commercial law be used, in your opinion, to make claims against businesses to combat greenwashing?
Well, that's a very complicated question, if I may say so. But it's not so much commercial law. And in fact, I was saying that only, there were some judges who had this sort of commercial background. And that's, when the principles were developing in the 19th century. They're still developing, of course, but that, that was the great age when our commercial law developed. But I mean, in terms of your proposition about environmental claims and so on, that's happening now. But it tends to happen more in public law. I mean, there was a very important case, of course, which was in the planning context about oil and gas development, which is still having repercussions. And that so it's a different sort of context. It's not so much commercial law; it's in other areas where your sort of interest would be manifest. I mean, if you're interested, there's at the LSE there's a centre where they're collecting all the cases on climate claims from around the world. And I was quite surprised. I had to give a talk some time back, but there were hundreds and hundreds and hundreds of cases around the world. Some of them not successful, of course, but some of them successful. So thanks for the question.
Any more?
Your first one was too difficult.
Maybe I'll try to give a more specific example then. Let's say that I, as a business, have decided to contract with a company purely on the basis of the fact that they have made certain green pledges online and quite publicly. And I'm deciding to pay an additional premium on the basis of this fact. And then I find out that they're indeed partaking in activities that aren't quite as green. Is there any sort of apparatus within the commercial law or contract law more specifically that can deal with this issue?
Well, I mean, it depends on the facts, obviously, but, basic misrepresentation. I would have thought that's your first port of call. And then, if you're buying securities, for example, you've got provisions in the financial securities law about false claims and so on, company law as well. There's
Thank you.
There's on.
It's exactly that.
Yeah. Which is what the BMW one, is it? So, there's a, if you go into this area, there's a lot of potential.
Any more? Yes, one more. Yes. This had better be our last, since we're getting on to 7:25. Yes.
Don't worry. Last one, I'll make it a fun one. You mentioned that you were an MP. We're not going to get too political, don't worry. If you were an MP now, which issues or questions would you raise to the government regarding not just commercial law, but maybe just the judicial system overall? What kind of issues would you want to raise and be fixed at the moment?
I would hope to be part of the government.
I think that's an excellent answer, Ross. Thank you very much. On your behalf, I'd like to thank Professor Sir Ross Cranston for the lecture this evening. It's given us all a lot to think about. It's obviously provoked a very lively debate in the last 20 minutes or so. By all means, continue it over drinks outside, but can we all thank Professor Cranston?